Welcome to the Trial Bible, where we break down the secrets of courtroom victories with the best trial attorneys across the country. Each episode will sit down to explore their recent winning verdicts, the key pattern jury instruction charge that made the difference, and the tools they use to hit big. Let's go. Hey folks, welcome back to the Trial Bible. And today's episode is a very exciting one. I've been dying to talk about labor law. That's what we're doing today. We have a monster case that was just tried just a few months ago, and we are in the presence of two of the greatest labor law attorneys in New York. We have the privilege of having Helena, Manesis, and Brian Brown of Zaremba Brown, two heavy hitter trial attorneys in this labor law space. How are you guys doing today?
Good. How are you?
Great.
All
Thanks
right.
for having us.
I appreciate you guys being here. I've been wanting to talk about labor law. Labor law is such a juicy field over the last couple of years. Everyone kind of wants to get their hands on some of these labor law cases just because the numbers are so high, but not to say they are not easy cases, and you really have to know how to properly litigate them, how to properly set them up from inception through trial, and all of the fields that you have to navigate in this space. So I'm happy that you two are here. I want to talk about the Begonia case that you guys just took a $20 million verdict on just a few months ago. Why don't you guys take us back to when the case first came in? Who is your client? What happened to him? What were the facts that immediately stood out to you here?
Sure. So Mr. Begonia was a local 12 insulator. This is going back to March 13th, 2020, Friday the 13th, like the last day of business before COVID and the shutdown. This project was a city winery project at Pier 57 on the west side. They were turning a kitchen, cabaret, theater area. City winery hired RXR as the GC. The GC then went ahead and hired an HVAC company, heating, ventilation, and air conditioning company. And they subbed out the portion of the insulation work to another company called John's Insulation. And our client, Mr. Begonia, was a local 12 insulator with John's. They were doing this work. His assignment that morning was to set up a ladder in the kitchen area and start insulating ductwork and pipes at about 12 feet, 15 feet in the ceiling. This job was behind schedule. It was a rushed job, okay? So the trades really weren't coordinated. There was already a drop ceiling in the kitchen. The kitchen equipment was, and the fixtures were already installed. So you had the countertops and the shelving, and he's trying to navigate all of this. The company had 5 guys on the job, and they brought 1 ladder to the job site. Obviously, that ladder was being used by one of the other guys. And so he had to go and borrow a ladder from another trade. He goes and sets that ladder up in the kitchen. And like I said, it was a very narrow area because you had countertops already installed on either side. So when you open up the ladder and he's now got to work through and reach through the ceiling grid to try and get to the pipes and the ductwork that he needed to insulate, and that's coming out of the wall on the side. He had to reach over to the side of the wall to get to that ductwork coming out of the wall. And as he did so, the inevitable happened. The ladder moved and he had a very violent fall. He hit the shelving, his helmet fell off. The testimony was very clear that he landed on this concrete floor like a pancake. He was knocked unconscious. He was convulsing at the scene. 911 was called. But like I said, this is during COVID. They were very hesitant to keep him. They transported him to the hospital, right? They kept him in the hospital for 2 days for observation. They did a lot of testing. He had a brain MRI. He had a cervical MRI, a multitude of x-rays and testing. He had already had immediate shooting pain down his arms. That was noted. Brian, correct me if I'm wrong. That was noted in the ambulance call report.
Triage notes.
Triage notes. That's where it all started. That's how it started.
So we have a couple of players here. We have your plaintiff, who's a worker. His direct employer is a company called John's Insulation. They are subcontracted. And then we have some direct defendants here, which is RXR. They are a general contractor on this job. And we have City Winery, which is the tenant that's occupying the space that needs the work done for their build out, right?
Correct.
Okay.
Correct.
So early on, how do you go about recognizing, or how does the firm go about recognizing that this could be a labor law section 241 case?
So, I mean, first of all, we have a construction worker who falls from a height. So that's a pretty good indication that we should be seriously taking a look at the labor law, right? And this is, 99% of our practice are union referred, building trade, union referred construction workers. And so we bring most of our cases under either 240 sub 1 or 241 sub 6 of the labor law. That's the world in which we tend to view these things initially anyway. And this is what we would consider a classic case. Now, you brought up a good point, Gennady, about, the labor law. Everybody wants to get their hands on them. Most people would think, guy fell off a ladder. This is a simple, straightforward labor law case. A first-year law student could handle it. But as Helena laid out with the facts of this case, it was clear to us pretty early on that there were a number of different theories that would have to be explored initially and throughout discovery, because it's not just as simple as going and getting your summary judgment on the labor law under 240 sub 1, because there's going to be all these issues that ultimately in this case came into play at trial on issues like the responsibility of third-party defendants, employers, the nature of the job, who was responsible for setting up the job site, the coordination of trades. Even though we had summary judgment for 2 years before trial, all those were issues that came out at trial because third-party issues remained in play to the very end. So, our investigation on day one wasn't as simple as, we got a guy who fell off a ladder 12 feet. We got a 240 case. We knew we had a strong liability case, but we also knew we need to do our due diligence because, our experience litigating these cases told us it's going to be more complex than that. And it was.
And for those that don't know, most of you do, but we got some attorneys listening, not from New York. The labor law 240 sub 1, it's often called the scaffold law. It imposes absolute liability on owners, general contractors, when a worker is injured due to a gravity-related hazard. That's why you hear Brian saying, fell from a distance. It's like a fall from a ladder if proper safety devices are not provided. So, Helena, you kind of already mentioned it. There was 5 workers there, 1 ladder, and the space that he's working in, that is not sufficient for the work that was required. Is that fair?
Correct. Typically, when you got a guy who needs to use 2 hands to work overhead, a ladder is not going to be the proper safety device. It's not going to provide him with proper protection.
My trial brain is kind of always on. I heard you mention this happened on Friday the 13th. Do you guys bring that in either in opening or at some point? Do you bring that fact in and kind of emphasize facts like that? I had a case where a person got hurt on New Year's Eve. And I always think about that. This is not how they plan to spend their New Year's Eve had it not been for the negligence, et cetera, et cetera. Did you guys do that here? Do you mention Friday the 13th or no?
No, I hadn't even thought to do that. But as you just mentioned it, I thought to myself, I'm glad we didn't focus on that, because I think Friday the 13th could be a magnet for excuse my French, but a shit happens juror. Like, it was just bad luck. It was Friday the 13th. It was just one of those things that happens on Friday the 13th, as opposed to the way we always try to frame our cases, which was this was a very preventable and logical outcome of poor planning and contractors who put time and money over safety.
So you guys mentioned that you guys did move for summary judgment on this. And I have to mention the fact that the direct defendants that you did bring in here was the RXR company, the general contractor, and City Winery. You did not bring in the employer themselves, John's, as a direct defendant. Why not?
Well, initially, we didn't bring them in because of the workers' comp bar. That's the short answer, right? So in New York, for those who don't know, plaintiff can't have a direct claim against his employer. So yeah, that's the reason why we never name the employer, because we can't. Sometimes, like in this case, get brought in as a third-party defendant under various theories. In this case, one theory was that there was a contractual indemnification claim between RXR and John's. And ultimately, what came out was there was another theory based on a grave injury. The grave injury theory was related to his brain injury, and that was really not clear early on in this case that would amount to a grave injury.
And am I right that under labor law 240 sub 1, plaintiff does not have to prove that the ladder was defective? They only have to prove that it failed to provide proper protection, and that failure caused the fall. Is that fair?
That is fair.
Okay. So summary judgment is granted in this case about 2 years prior to trial. How does that change your trial preparation?
Dramatically. The way we do things in our office is usually about a year to 15 months out from what we think is a realistic trial date. We begin the pretrial process, and usually by that point we know whether we have summary judgment or not, which we did in this case. So obviously that means that we're going to confine our preparation to issues relating to damages. Even in this case, where we knew that there would be issues still being litigated amongst the defendants on these contractual claims, as far as we're concerned, those are not our issues. So we focused entirely on damages.
All right. So turning to damages, how old is plaintiff, Mr. Begonia, when this happens? And walk us through all of the injuries that come from this fall.
He was 47 years old at the time. He had the injuries were herniations in the neck and the cervical spine, herniations in the lumbar spine. He had a chondral defect and I think a lateral meniscus tear, if I recall correctly, in his right knee. And then, of course, the brain injury.
It's not clear because of the way the verdict sheet reads what injury the jury attributed most of his damages to. We try a lot of spine cases in this office, and we try a lot of orthopedic injury cases. We occasionally try brain cases, right? We've seen more of them over time. We look for certain things initially to determine whether or not this is a case that we think has the potential to be a traumatic brain injury case. And Mr. Begonia had those things right off the bat, which is there was a loss of consciousness. He was worked up in the initial hospital admission for a potential brain injury. But he didn't have certain other things that you might see in a case where you'd say, whoa, this is a big brain injury case, which was when they worked him up in the hospital, the initial CT scan and MRI of the brain were negative, right? There was no skull fracture. There was no brain bleed, thank God. So in those cases, what will happen is sometimes we let the plaintiff and his treaters guide us, right? That's, I think, the best way to do it. Let their symptoms and their clinical presentation dictate what the treatment will be, and then we follow that, right? So with Mr. Begonia, I think for the first 2 or 3 years of the case, we viewed this as primarily a spine and knee case. He also had a tear in his wrist, which he'd never had surgery for, although it was indicated. But we monitored the situation with the brain injury, and he persisted in making complaints about it, both to us and to his treaters.
About the brain,
that he felt like his memory was getting worse and the headaches were getting worse, not better. And those can be, very subjective complaints, and they can be tough to objectify and quantify. And, it's not uncommon that we have a presentation like this where we have sort of subtle findings initially regards to a brain injury in the treatment records, and then the patient will say, this is how it's presenting in my life. So at some point we decided, well, not actually we, his treaters decided that he needed further workup, and he was sent by his neurologist in 2024 for a specialized MRI called an MRI with DTI, which is a very specialized type of MRI in which you can see essentially microscopic damage in the brain that's not picked up on a more gross level. And when we got the results of that, I'm pretty familiar with the medicine around those and having tried cases involving them before. And I looked at the findings and I said, these look really significant, but I really want to make sure before we go all in on this brain injury in terms of our trial strategy and trial prep. And so we sent it for review by a neuroradiologist who I believe is, the leading expert in the country on TBIs from a neuroradiology perspective. And that's Dr. Michael Lipton at Columbia. We sent him the films and the report from that MRI, and we waited to hear from him. And I still remember Helena and I were in our office. It was sometime in the fall of 2024. And Dr. Lipton said, I have time to talk today about this. And we got on a Zoom with him, and Dr. Lipton said, is this guy okay? And I said, yeah, but he has these persistent complaints. And he said, well, what is his clinical presentation? And when I told him, essentially, he's not a vegetable. He was functioning and still able to do things. He could still drive a car. He could still do household tasks. He said, I'm surprised because these are significant findings. And we went over them. And then at that point, we decided we really need to pursue this at trial. It needs to be a major focus of the trial, and it was.
The traumatic brain injury on all of these personal injury cases, I find so many are missed because there's such a wide range of that level of injury of the brain. We know less about the brain than any other part of our body. And, the last TBI case that I tried, I started questioning. I have a sister-in-law that suffered a TBI from an accident. She sounds like she slurs. And, to other people, she sounds drunk when she's around. But that's just how it affected her. You start to ask questions that normal people don't know. And I think forming to the jury what the injury is a challenge in and of itself.
Yes.
How did you, in this particular case, go about walking this jury through what it is that he was suffering from when it came to the traumatic brain injury?
Well, I think for us, in my experience with these traumatic brain injury cases, it's kind of like a three-legged stool, right? The clinical picture, which is how is this manifesting in the patient's life on a day-to-day basis, right? Is he able to do simple tasks? What does his family say about him? How does he present when you talk to him? Does he slur his words? Those are all the clinical picture. How is he done on memory testing and things like that? The second leg of the stool is what you get in terms of objective testing like radiology. And for me, the MRIs and the MRI with DTI is the most significant part of that, much more significant than neuropsychological testing. He underwent a series, I think he had 6 in total neuropsych tests throughout the course of 4.5 years, 5 years. And his findings were all significant deficits. If that was all I had, I would not have felt nearly as good about trying this, focusing on the TBI trial. I would have focused more exclusively on the spine and the orthopedic injuries. The third thing is, and I think this is really important for people who have to try these cases, and I think everybody should think about, if you're going to present a TBI as a significant portion of your damages, you need to be ready to try it. And I think the third leg of the stool, from my perspective as a trial lawyer, is mechanism of injury and initial presentation, right? So, and this goes just more to my experience with jurors and juror psychology and how they make decisions, right? If the initial presentation is of a nature that a juror says, whoa, that seems like that could cause a serious injury to somebody's brain, that looks like somebody who's going to have serious brain problems at initial presentation, then I feel much stronger about presenting the rest of the evidence that supports that. And he had that in this case. We had photographic evidence taken by a coworker on the day of the accident that showed him unconscious lying on the floor. We had accident reports in which another coworker who ultimately testified at trial said that he was convulsing on the ground. And I think when you have that initial mechanism of injury presentation, it's much easier to get the jurors to connect the dots to the evidence that comes later down the road in the form of objective testing and his clinical presentation.
So I'm showing you one of the photos here. I believe you guys blew this up and used it quite a bit during your trial, which is an actual photo of Mr. Begonia on the ground almost immediately after the accident. Is that right?
Correct.
You're almost talking about the biomechanics of how this brain injury occurred and kind of the proof here of, look, he's laying completely lifeless. And that's where the injury starts.
That's right. There was a couple other key, facts in the record and pieces of evidence about that initial presentation. The initial 911 call, reason for call, the dispatcher wrote unconscious patient, right? And then as we talked about, there were multiple mentions of him being unconscious in the accident reports and of him convulsing. And why that was so important is because when you have a more subtle initial presentation, one of the features of the defense in all these TBI cases is that, this guy didn't have a serious brain injury. There was no brain bleed. There was no skull fracture. The people at the hospital didn't work him up for it. And they tried that in this case because by the time he got to the hospital, he was alert and oriented ×3. There was a lot that they had to work with, which they did in terms of highlighting for the jury. There were you have those triage notes and then the nursing notes that get repeated throughout the hospital admission where somebody's checking off that he's neurologically intact, right? They showed that to the jury over and over. What brain injury? This guy was neurologically intact. He was alert and oriented. He had a Glasgow coma scale of 15. We must have heard that 50 times from the defense during this trial. And they went deep with what it means to have a Glasgow coma scale of 15. It means you're totally fine. We, through our experts, were able to show that a Glasgow coma scale is, not at all predictive of whether or not you have a traumatic brain injury, particularly after a loss of consciousness.
Okay. So we're talking about herniations of the neck and back, a knee injury, and a confirmed traumatic brain injury. What is your mindset walking into this damages only trial as to how you are going to use your witnesses, in what order, and what you're focusing on?
That's a great question. We did in this case, and we generally do like to put our plaintiff on our client.
Tell me why. I get so many conflicting versions of this, of what lawyers want the jurors to hear first. Tell me why you guys like to put on the plaintiff first.
I have a very cynical view of this that I'm almost reticent to share. I started my career trying medical malpractice cases. I got very comfortable with the idea that when the trial was all about the defendant and their conduct, I have a really good chance at doing well, particularly if the conduct is of such of a nature that it might scare the jury, right? So when I started trying damages only labor law cases, and everybody's like, you're so lucky, you get these great labor law cases, you got summary judgment. And I knew from one perspective, we were very fortunate to handle these type of cases on behalf of injured building trade union construction workers. And I wouldn't want to trade this practice for anything else I've ever done. But from a trial lawyer perspective, I kind of hated it at first, right, when I started trying these cases, because I was in the position where the whole frame of the trial was, is my client a liar? Is he a faker? Is he a malingerer? That was the frame. I felt like I had to disprove that. We started putting the plaintiff on first because I felt like if I'm going to have a 3 to 4 week damages only trial, I'd like my client to be in some ways forgotten about pretty early on, because I don't want this trial to be about my client. I want it to be about the defendants. Like in this case, there were issues of liability that got to be tried, even though we had summary judgment, which was kind of like a best case scenario for us. So the jury did get to hear about decisions that were made, that this was a rush job, why wasn't a man lift provided, why weren't the trades coordinated properly. I want that all day. And sometimes I don't get that because it's a one-on-one damages only. But when we don't have that, we still have, which we had plenty in this trial, which is I want it to be about how are the defendants defending this case. Let's look at how they're defending this case. Let's look at the extremes that they go to, these experts they call in every case, and the things that they'll do to try to avoid responsibility. That's the frame I want for the case. So I like my client on early, set the scene, lay out the facts, but exit stage left. And listen, in this particular case, he's a sweetheart of a guy, and he was a good witness. And Helena in particular, and Dan Gluck, our partner, who spends days and weeks and months prepping our clients for depositions and trials. They did a great job. But yeah, that was the plan. Put him on first.
Helena, tell me a little bit about the prep on Mr. Begonia. It's really tough to talk about traumatic brain injuries to someone that, they can't see it for themselves. They don't always know the side effects of it. I usually start contacting families and kind of asking, how are they different and all that. What did you do here with Mr. Begonia?
I mean, it's hard to prep somebody that has a brain injury where they have memory loss. He has crippling anxiety. So just even the lead up to the trial, the anxiety, you could see it building, and it was then affecting like how he was retaining information. And it was very, very difficult. You had to do blocks of time. You had to watch your tone. You had to watch the words that you were using. Even at trial on direct examination, he had an anxiety attack and was like, I need a break. So it was definitely challenging. Dan Gluck is phenomenal at prep, and he's got a great personality for clients who have this type of a manifestation of symptoms. In my opinion, you have to keep them calm, trying to keep them focused. It's challenging. I mean, there's no other way to get around it. It's challenging.
I want to talk about the two of you, the dynamic in trial. I'm sure you guys have done trials alone. We've all done trials together with co-counsel. Do you guys prefer the co-counsel? Would you rather do it alone? Here on this kind of case, how did it help the two of you get the result that you got?
This was the first trial we had like together where we were both questioning witnesses. I loved it. I wouldn't trade it for the world. I've been working with Brian for 12 years. I've started here as a baby attorney. In fact, they hired me before I was even admitted. It was a great opportunity. Brian's my mentor. So I've been under him for a long time, and to like try a case together and question witnesses together was awesome.
Brian, how was it for you? I mean, I heard you're not only mentoring Helena, you're a mentor to a lot of people from what I hear. So how was that experience for you?
Well, it was great. I mean, it was phenomenal. It was gratifying. Here's the thing. To answer your question about would you rather try cases alone, I tried a lot of cases alone early in my career, not because I wanted to, because I had to, right? We didn't have enough people working here. I didn't have the resources. I would never go back to that if I didn't have to. I really enjoy, and I benefit tremendously from having really good second seat at trial. Sometimes I'll take a lawyer who's a little, less experienced, right? It's an important part of the process at our firm. But to do it with Helena, we had tried cases together, but it was when she was a younger lawyer and she was like a true second seat. And it was mostly, we talk a lot of strategy and stuff, but she didn't have a speaking part. But now she's gone off and tried her own cases. And to see someone who you've been working with since they first started. And look, Helena's a rock star. I watched her on trial. I've watched her on trial by herself. She has a great way about her. There's definitely a different level of confidence, right? I knew she was going to do certain witnesses, and I didn't have to think about that.
Yeah.
That's a huge lift when you're in the middle of a trial to be able to focus on what you need to focus on and not have to worry that your partner is going to hold up her end of the bargain.
And it's a second trusted brain who has another set of eyes, who's seeing things and hearing things on the spot that I don't know if you guys do the index cards, passing to each other throughout the trial. But I personally love that experience. I got to do it with some of my mentors, and I thought it was really special, especially during jury selection, where you're really seeing things a little bit differently and you have another set of eyes to catch what maybe you missed. So you said you put on the plaintiff first. He did pretty well. Who was next for you?
The next witness was a coworker who was important to, verify the happening of the accident and also to, lend credence and support to the plaintiff's version of events, but then to be the first, the real eyewitness who could talk about the initial presentation and the extent of the injuries and the concern that the coworkers had there that day for him. That it's always whether you're dealing with a spinal case or a TBI case, it's very, very helpful for us when we have an initial presentation that is dramatic and the mechanism of injury really matters. Sometimes we don't have that. It can be difficult, and the guy's got a serious injury and you're fighting that uphill fight the whole trial. Good defense attorney will just keep going back to the mechanism of injury. I don't know, the guy fell 3 feet. He limped a little bit. He went back to work that day. He doesn't see a doctor for 2 weeks. Turns out he needed a total knee replacement, right? But that's a tough hill to climb. When you have a case like this with facts like this, I'll beat a dead horse at trial, right? So like the fact that we had a second witness in there to talk about the initial presentation, to describe it, and we spent a lot of time with him because we thought that would help sort of fortify us against what we knew was coming from the defense, the attacks.
And that's not always easy to get on these construction sites, to get another person to come in that may or may not speak English, may or may not want to be involved with the court process. Not always so easy to have those witnesses.
We're fortunate in that because the great majority of our clients are union affiliated, and, we're a trusted counsel to a lot of the building trade unions. That spirit of fraternity and brotherhood and sisterhood in the union, it definitely helps us to get the support of and the help of witnesses.
What did you guys think was defendant's position walking into this case?
Direct defendants or third-party defendants or both?
Well, tell me both.
The case had been mediated more than once, so we had some sense of, they knew this was a serious case. I think they viewed it primarily as a spinal case until just before trial. I think they valued it based on the spinal injuries alone. And he had some priors, particularly on the lumbar. There was going to be that usual fight that we have on spinal cases. I think they viewed it as, the plaintiff has a relatively strong spinal case here, and he's got a big specials package because he was a union worker and he was sort of in the prime of his career. And, they didn't think this was some made up case, or that our guy was really a true malingerer. but that didn't stop them from, trying to raise that specter
course.
in front of the jury. But I think that they had real questions about the brain injury and whether or not we could really get that across the finish line.
When it came to the spine, was there surgery?
Yeah, he had cervical and lumbar fusion, both.
Multi-level, single level?
Multi-level.
On both the neck and back?
Yep.
And so I saw the jury charges, and I'm curious as to what the judge did. There's two different jury charges that deal with prior aggravation and susceptibility. They've isolated those two charges, which are 282 and 283. I saw you guys requested both of them. Did the judge give both?
That's a great question, Gennady. I don't remember. I know he gave at least one. Do you remember, Helena?
I'm thinking. I don't remember. I want to say no.
Because I just had this on a case and the judge gave one. He gave susceptibility because the way I flushed it out to the judge is if the person is not dealing with the injury at the time of the accident, then he's susceptible to a further injury because of what happened to him in the past. If he or she is still currently treating, then it's an aggravation. And the judge agreed with me. So I'm curious if you guys had the same ruling.
I actually think he did give both. Now that you mention it, I'm just thinking back. I think he did give both. And I remember being a little surprised that he gave us the susceptibility one, not the aggravation one, because that was essentially how they kind of walked into that one, as they often do. For those who try spinal surgery cases, I do scratch my head. I don't want to give too much away here. I hope there's not too many defense attorneys who watch this, but I'm always find it very strange that they go so hard on the pre-existing degeneration stuff against my clients when they really walk into the fact that when we're dealing with union construction workers, of course, a career of 20 years, they're going to have some degeneration. We always concede that. Our experts concede it because it's true. But we know that on the day of the accident and the day before that and the day before that and weeks before that and months before that, and according to his union records and his tax returns for a decade or more before that, whatever pre-existing degeneration he had in his spine wasn't disabling him. And then this thing happened, right? And jurors understand that.
Here's my opinion on why they go so hard on that is because people are not prepped for depositions properly. And in the depositions, they go a little bit further and the client will say, no, I've never had an injury like that. And they pounce on that. And if the clients were prepped a little bit better for deposition, not that you've never had it, but never like this is a big difference. All right. So we talked about Dr. Lipton. Who else did you have in terms of your damages witnesses?
Dr. Greenwald was next.
What did you use him for?
He was the TBI specialist.
Yeah, Dr. Greenwald, Brian Greenwald out of New Jersey. He is board certified in brain injury medicine. He is, I think, along with Dr. Lipton, they're different specialties, but I think you're talking about really two of the absolute premier medical experts. I don't mean testifying experts. I don't mean medical legal experts. I mean physicians who treat brain injury. And so Brian had seen, after Dr. Lipton had told us in the fall of 2024 that he felt like this was a significant structural brain injury from what he was seeing, we sent him to go see Brian Greenwald, who he had not been treating with. Dr. Greenwald's in New Jersey, the client's out in Long Island, but we wanted to have him seen by a true expert, and we did, and he testified, and he was great. I mean, he does a great job of explaining the anatomy to the jury, the structural nature of the damage that occurs when you have this type of an axonal injury to the brain, and then how that manifests matches up with what we're seeing in his records, but also how is it going to manifest as he gets older and encounters the sort of normal age-related problems that everybody does on top of this structural damage to his brain. He really did a wonderful job of explaining that in a way the jury could understand.
Do you guys bring in demonstratives when he's talking about the brain? Like what?
Well, we have demonstratives that show the mechanism of an axonal injury to the brain. We had demonstratives. We actually were able to use images from the MRI with DTI, in this case, to show the areas of the brain that were most impacted, which in this case was the corpus callosum. And that was significant because both Dr. Lipton and Dr. Greenwald were able to explain to the jury why an injury to the corpus callosum is highly, highly likely to have been caused by trauma, right? Especially if the patient has no other neurological disorder or disease, and our client didn't. And then explain how that manifests in terms of It affects both sides of the brain. It's in the center, deep into the center of the brain, and the inability to communicate when you have damages to the neurons in that area of the brain, right? And the axons, and the whole communication system for the entire brain starts to break down. And then over time, you expect to get white matter atrophy throughout the brain. They're not communicating throughout the brain. In this case, he had significant white matter atrophy. His gray matter, his overall brain mass was above average. For some reason, I seem to remember his overall brain mass was 84th percentile. But by the time we got to trial, his white matter was in the first percentile.
Is the client sitting with you guys throughout the entire trial?
No, in this courtroom, the client sits in the gallery, and he sat with his mom.
I meant, was he present?
Yes.
Throughout the whole trial, sitting with his mom. Tell me some other highlights that you think really kind of swayed the case one way or the other than Dr. Greenwald's testimony. Where did you think you kind of walked away and said, I think we really won right there?
Brian's cross-examination of their orthopedic surgeon was certainly a highlight.
Tell me a little bit about it.
He put on a clinic of like what cross-examination of a doctor should be. The doctor didn't review records. I mean, Brian got him to concede that. Brian got him to concede everything, and at the very end, got him to concede that Mr. Begonia, more likely than not, will require a total knee replacement in the future, which, by the way, was not in our treating doctor's records. So to get this doctor to concede that on the stand was, I mean, it was phenomenal.
That being said, I got fortunate. You know, sometimes you get a good break. I had not seen a lot on him. You know, when he came up, I said, man, you know, nobody has transcripts. I went around the wheel. I sent it to all the normal places. We send inquiries, and we got like 2 transcripts. And I couldn't understand why. And then I talked to somebody, I don't remember who now, but somebody who lives out in Long Island where he was. And they said, you know, he's a really good guy and a good surgeon. And I said, well, let's hope he's honest. And he was. He was just an honest guy.
What was his name?
Freeman, Eric Freeman. Yeah, Dr. Freeman. I thought he was very honest. At the end of the day, he said, I think one of the things the defendants failed to realize wasn't a big focus of ours until we were prepping for trial and we met with our knee surgeon was this wasn't a simple, you know, knee tear, meniscal tear. There was a large chondral defect, you know, right on the weight-bearing surface of the knee. And again, because of the initial presentation and mechanism of injury, the jury understood, oh, yeah, if he fell that far, that hard, that could cause that. And at the end of the day, Dr. Freeman said, yeah, if he doesn't already have arthritis in that knee, I'm sure he will. I would agree it's more likely than not that he'll need a total knee replacement because he's not yet 50 years old. That was a good moment. I think there was a number of good moments. I think Helena's direct of The Economist was like seamless to the point. It was Dr. Deb Dwyer, who, you know, we've used several times in the past. And what I like about her, we've used other economists and they kind of, I don't want to say they fluff up the numbers more, but their analysis is more complex. And Dr. Dwyer really just lays out the numbers, right? And she tells you where she got them. And she's very matter of fact. And Helena was able to bring out Dr. Dwyer's credibility and then explain her analysis in like very straightforward terms to the point where at the first thing that happened once the jury got the case, this is always a good sign, Gennady. You know, I've gotten some good notes in my day, but within 15 minutes of going back into the jury room, we got a note from the jurors said, can you just give us the final page of the numbers from Dr. Dwyer's report?
You gotta love that.
Yeah, that was a good moment.
What did Dwyer recommend? What were her numbers on this? And what were they based on? Was it just lost earnings, future medical? What did she do for you?
Don't forget, gotta remember he's a union insulator, so they got packages. So she goes and looks at your past, your economics, obviously, which would be like the straight wages. And what is she basing that off of? She's looking at your union records. How much are they making? How much are they working? And then she prorated the year that he worked, or the year of the accident, I should say. So 2020, she annualized that for the year. How many hours would he have worked and how much would he have made? So she's looking at, you know, his past, straight economics, and then obviously his future economics in terms of straight wages. What about the annuity, the pension, the vacation, the loss of health insurance, and things of that nature? So that was then included. So her numbers for lost earnings was $944,089, which is the exact number that the jurors filled in on the verdict sheet. Future lost earnings was $3,432,572, which again was the exact number the jurors filled out. We also had a life care planner. So that would have been Dr. Stewart Hahn. Brian, you want to talk a little bit about that? Because then Deb took those numbers and projected them out using inflation and same numbers that the jurors filled out on the verdict sheet.
We use Dr. Stuart Kahn, who I've known for a long time, is a really good guy to work with. I have a lot of trepidation whenever I put my life care planner on. We have to put them on, right? We can't not board those numbers for our clients in front of the jury. It's like one of my least favorite days of the trial, right? Mm-hmm. Because invariably there's things in there in those reports. And this is, I've learned everything I've ever done as a trial lawyer, I learned the hard way, right? I sat and listened to cross-examinations of life care experts that I put on. They're being cross-examined about why they're including couples therapy and a sexual specialist to help with their love life and a guy who's now divorced from his wife anyway. And these kind of things. And I said, oh man, I'll never do that again. And we try to present a pretty stripped down life care plan to, I'd rather them feel like that everything on there they can defend fully. We did that in this case. And I think we probably stripped it down a little too much. We missed the knee replacement, but I think the jury gave it to us anyway. But no, Dr. Khan did a great job. Why I like Dr. Khan and some others that I've used over time that I think do well with jurors is because his resume, his CV, what he's actually done in terms of practicing rehabilitative medicine, the places he's done that, the people he's treated, the institutions he's worked at, gives him a lot more credibility than some of the life care planners that I may have used in the past, where their only background was in the litigation business.
So we talked about all these experts, how you guys went about it, a little bit more of a traditional route where you put your plaintiffs on, your fact witness, your doctors on, and then you did the cross. In terms of jury selection, is there a certain kind of juror that you're looking for or avoiding when it comes to this kind of labor law damages only kind of case? And in this case in particular, do you remember any jurors that stood out that you said, this person's not good, and maybe use them as an example for the rest of the room?
Oh, definitely. We had a couple of those. I will tell you that this is one of the more difficult jury selections I've ever done. And I've tried cases in a lot of upstate counties. I've tried cases in Staten Island. We started the Monday before Thanksgiving, and we went until like 4:00 on the Wednesday before Thanksgiving. We went through 130 jurors before we were able to get 6 and 3.
Wow. That's
because
a lot.
Nobody wanted to sit for a 3-week trial just before Christmas. And what we found, is that starting jury selection the Monday before Thanksgiving is a bad idea, because what you're going to get is everybody who was able to get out of jury duty previously for excuses, scheduling, and then figures I'll go that Monday and I'll get out in one day and then I'll just have the rest of the week off. Right. And so we had 2 defense experts, like well-known defense, I was going to use a derogatory term, but defense medical experts in one of the panels. I mean, we had a lot of finance guys, finance bros. The one in particular I'd used in the way you said, I could tell based on his persona, young guy, I'm just suspect of these type of claims. And, rather than run from him, I knew that there were, his persona was kind of hostile. And I just figured the people I want on this jury are going to find this guy pretty contemptible. So I let him go for a while, and then, tried to bring out the fact that he doesn't apply that same level of suspicion to things like corporate fraud or, it's only when you're talking about an injured construction worker, you're suspect. Then we cut his head off. It was a tough panel. In every case, the main thing I'm looking for, and this may seem overly simplified, but it's my truth, I want optimistic jurors. I want community-oriented, optimistic people. And we have a whole series of questions that we use to try to ferret out who those people are. I want to get rid of cynics. I want to get rid of people who think that shit happens, that the system's rigged. And ultimately, we ended up with a really good panel. I didn't know they were a great panel till well into I had questions all the way through till pretty much the last couple of days of the trial.
You want people that have family members in unions and are construction workers? Is that kind of
if we can keep them? I mean, they can be tough to keep because a good defense attorney can often get them talked off. that they would feel some level of sympathy for the worker, or they lean a little bit towards the worker. But obviously, yeah, if you can get one of those people on your jury, that would be great.
And so in your opening and closing, what's the overall theme here? Are you focusing on the brain injury? What are you really kind of over talking about so that the jury really understands what this case is about?
Well, our opening theme and closing theme was the same, which is this is fundamentally a case about responsibility and about companies that didn't take responsibility when it mattered and have tried to avoid the responsibility for that all these years later. And then of course we get into the medicine and opening. I do a lot with spinal anatomy during the openings. I use models. We use diagrams during the opening. We always use a PowerPoint, which I think is really helpful. If anybody's not using PowerPoint in their opening at this point, you really should be. And we have a canned memo of law. If you ever have an objection to it, particularly in the first department, you'll have no problem. The reason I do that is because I really believe that jurors, if they can see something, it's a big advantage to go first. It's a big advantage to go first. And if you're showing them things right off the bat, it goes a long way towards establishing your credibility on those issues right out of the chute. And that was the case here. We were able to show them, medical records, images from the MRI films right during the opening, be the first ones to tell them what it was. And that's just a huge advantage.
That's great. Any other key highlights that we haven't spoken about that you think are useful for attorneys to know on these types of cases?
Well, I want to give Helena a chance to talk about some, but I just want to mention, I think the most important part of the pretrial workup for us and our analysis, and that was true in this case, was you can't be scared of the weaknesses in your case. And you have to assume that you're going to be up against competent counsel who's going to find them and is going to magnify them to the jury. And there were a number of things in this case that we had concerns about. Our guy had significant priors. A month and a half before the accident, he's at a doctor's office saying that his back pain from a car accident 3 years earlier, where he had an MRI that established he had herniations at the exact levels where surgery was done after our accident. And he's complaining that it's starting to affect his ability to work. It affects his ability to go up and down ladders. And, so what do you do with that? You don't hope that the defense attorney doesn't bring it up, right? You got to frame it. You got to deal with it in direct of your client, which Helena did. There was no weakness in our case that the defendants didn't seize on. The defense attorneys did a good job. They knew what the weaknesses were in the case and they went at them. And I think the fact that we got ahead of them in our framing was really important. Would you agree, Helena?
1,000%. And one thing that we didn't talk about that I thought was challenging, or a challenge for us that we had to overcome, was the surveillance video.
Yeah, they had a lot of surveillance.
9 months.
How did you guys deal with that?
So we learned the hard way. I learned the hard way from previous trials. And a few years ago, we started a practice in our office where once we get surveillance, we have a set of demands and we have a motion ready to go if we don't get the responses we want. And all that played out in this case. And one of the things that we really try to do is take depositions before trial of the investigators who do the surveillance. And we find that to be very effective. And based on those depositions, we then choose one or two of them. In this case, it was one that we call as a witness at trial, one of the investigators. And why is that important? Otherwise, jury is just sitting there watching these, highly edited cuts of, in this case, 9 months. There was over 112 hours of surveillance performed on him. And on the surveillance, he does not look like a disabled man, right? He is living his life. He's driving a car. He's running errands. He's going to and from the store. He's carrying a tank of propane, for his grill. He's helping his father fix the sprinkler system in his house. He's working on a compressor outside the house. That was scary, right? So if you just allow that to be played, and that's the story, and the defendant frames it the way they want, you got a problem. If you call a witness that you can essentially cross-examine, which we did in this case, and you make the point, which we did, that the jury was shown 22 minutes of video surveillance, and you surveilled him for 112 hours. And there's usually, in the logs, there's going to be things, there's little nuggets of gold, which there were times where they, how many times they went to his house. The great majority of the times they went to his homes, and he never left the house. The last question I asked of the investigator was, after the kind of worst portion of the video was shown, where he's doing all this work with his dad on the sprinkler system, he's bending over and he's using both hands, and he's, he looks pretty active. The jury saw that, and I asked him, I said, we just watched 12 minutes of video from July 9th, 2024. It was a day you came to my client's house. You sat outside his mother's house for 6 hours. And for 12 minutes, you saw him helping his elderly father perform some household tasks. He said, yeah. I said, where's the video from July 10th? And he starts checking his notes. He says, I don't know. I don't think there is a video from July 10th. I said, right. So you have no idea what condition he was in on July 10th, do you? You don't know if that was one of those days where he couldn't leave the house because he was in so much pain, do you? He goes, I guess not. And the jury gets it, right? Like, this is highly edited, fabricated, essentially, to give a false impression.
That's the difference between playing defense and offense, and getting ahead of these issues and framing it in a way that by the time they present it, they're already skeptical of what it is that you're presenting. That's beautiful. That's gold. That's gold. That's what this show is about. Those kind of gold nuggets. Anything else?
That's it.
Because I love to ask. I don't know if you guys want to talk about it, but I'm going to ask. You guys want to tell me what the pretrial offer was?
Pretrial offer was $4.5 million.
Well, no. So let's just back up. They asked to mediate the case. We went to mediation. The combined offer was $800,000, mostly due to, the third party issues, who was putting in money and blah, blah, blah. The mediation broke down at that point. There was no other offer made until trial. And once we were there, Judge Kelly was really, I think he rolled his sleeves up and really made an effort to try and get the case settled, which I don't think every judge does. So I thought he made a very good effort to try and get the case resolved. Wanted to know, like, hey, well, what's the bottom line number? I'm going to go get you that number. Because of those third party issues, they just didn't want to put the money up. So I think the offer was like $6 or $6.5 million.
Went from 4.5 to 6. And ultimately, the Friday before, the verdict was a Wednesday. The Friday before, Judge Kelly called me into chambers, and he said, I know you told me 8 is your bottom line. I just want to know, if I tell them to get you 7.5 by Monday morning, will you take it? And we had a really anxious client. And I knew the trial was going well, but we had a really anxious client. And that's a lot of money that would make a significant difference for him. So we spoke to him, and by Monday morning I came back. I said, okay, Judge. And they did not come back with $7.5 million. They came back with 7.25. And I said, well, there's your answer. I've already gone as low as I'm going to go. And they ultimately came up with 7.5 once we finished summing up. But by that point I said, it's too late.
No high-low in place?
No high-low.
Did you talk to the jury after?
We did.
Give me some of their feedback as to what they liked, what they didn't like, what they tell you.
I believe every trial is essentially a war for the high ground of credibility. And they felt like we told them what we were going to do, and we showed them what the evidence was that supported it. And they never found any of the defense evidence to be very convincing. They particularly did not like the defendant's neuropsych. They did not like him at all. I think I may have already mentioned him by name, but I sincerely hope defendants keep calling him, because I've crossed him several times and he's not an effective witness. I will say the defense spine expert in this case is somebody who's come up a lot. I know a number of other plaintiffs' attorneys are familiar with him here in New York, Dr. Kim, and we're seeing a lot of him. It was my first time cross-examining him. I thought it was the worst day of the trial for us, because he's a very effective and cagey witness. And I thought I let him get away from me a little on cross, and I got a little perturbed with him because he's very cagey. The jurors, their feedback was consistent with my view of how that day went. They said, he gave him some things to think about on the spine. He's the head of degenerative spinal medicine at NYU. And the only point we could really make on him was, if you're a hammer, everything's a nail. And if you're a degenerative spine specialist, everything's degeneration, right? Could never be causally related to an accident. Yeah, all in all, I think they just felt that we showed them the goods, and they followed the evidence.
Well done. Well done. It's a pleasure to have you guys on here, folks. You've heard it here on another chapter of Trial Bible. We brought in a labor law damages only case that was not as straightforward, and it's not so easy to just get $20 million on this case without doing the work from the beginning, without filing these extra motions on the surveillance and everything else that goes into it. There is so much that goes into it before you step foot into the courtroom. And that's exactly what Helena and Brian showed us. Guys, I want to thank you again. I appreciate your time and coming on here. And we look forward to the next verdict out of Zaremba Brown.
Thank
you
you
so much, Gennady.
All right. That's a wrap for this episode of The Trial Bible. We hope you've gained some valuable insights. Don't forget to subscribe, rate, and review so you never miss an episode packed with winning tactics and expert advice. Thanks for tuning in.